Now, first and foremost, 50% is constitutionally sanctified was missed by every member of the court. Everyone missed 16(4)(b) because 50% is now recognized in the Constitution. It's no longer a matter of looking at Indra Sawhney. It's a matter now of constitutional principle. And therefore, if you missed this extremely important provision, the entire judgment is rendered in that sense per incurium. So the 50% cap, which is constitutionally sanctified, has to be adhered to. What they could have held, of course, was that given 50%, because don't forget, 16(6) and 16(4)(b) have to be harmonized. 4b lays down the cap. 16(6) gives 10% more. Now it's up to 10% more. So that when you have up to 15% for scheduled castes, 7.5% for scheduled tribes, 27% for OBCs, you've already reached the figure of 49%. And if you're going to add 10 more, you reach 59%. So the correct way of harmonizing the two articles would have been that you stick to 50%, but you can reduce something within the OBCs so as to fit in, let's say not 10%, but something down the line of 5%, 6%, 7%, so far as the economic people are concerned. But I now come to the very basis of the judgment. According to me, Article 46 does not at all sanctify a classification based on economic criteria. A simple reading of the article itself will show you that, because the last part again is completely missed by all 5 learned judges. 46 begins by saying that it shall be the duty of the state shall protect. And basically what the state shall do is to promote the interests of, which are, and by the way, the interests are stated to be educational and economic. So the state shall promote the educational and economic interests of the weaker sections of the people, in particular the scheduled castes and tribes, so as to protect them from social injustice and all forms of exploitation. If you read the article as a whole, there can be no doubt whatsoever that the weaker sections spoken of in the article are those who require to be protected against social injustice and all forms of exploitation. Now, what you have actually achieved is to do exactly the contrary of what Article 46 tells you to do. Though the statement of objects and reasons of the 103rd Constitution Amendment Bill was that we are doing this in pursuance of 46. What you have achieved by the amendment is nothing short of turning the Constitution on its head. Why do I say so? First, you exclude all those who require to be included. So you exclude scheduled castes, scheduled tribes, backwards. Having excluded them, who do you include? This is most important, not looked at. You are only including upper castes. If you keep all these people away, who do you include? You only include Brahmins, Kshatriyas, Vaishyas, and also Muslims and Christians. Now this becomes a huge problem, because when you include these people, the founding fathers would say that there's no question of any reservation except because there has been historical wrongs done. Where persons have never suffered from these wrongs, you are now reserving something for. And where historical wrongs have been suffered, you are not reserving things for. So actually the Constitution now is turned on its head. And for Muslims and Christians, don't forget, the presidential list of scheduled castes under Article 341 specifically said it was only for Hindus. You could not have Muslims and Christians in it. And therefore, the founding fathers said, since there's to be no reservation for these two categories, we will give you another right which people don't have, Article 30. And Article 30 is the right which is given to minorities to establish and administer institutions of their choice. Now, all this is given a complete go-by. And we find that there is an amendment now which has turned the Constitution on its head, which is now completely sanctified by these three learned judges. Justice Bhatt also, in one other segment of his judgment, says that there's an additional reason why 16(6) would be bad. 16(6) does not have what 16(4) and 4A have, namely, that everything has to be posited on adequacy of representation in the service. Now, there is no adequacy of representation in the service under 16(6) when it comes to economic criteria.